Welcome to episode 29 of Let's Talk Money with Wendy Silebi. Today we are honored to be chatting to Sheila Ann-Robey, who will empower us with wisdom around wills. Sheila is a certified financial planner and a practicing attorney. Now for our topic today, just to paint a picture, several years ago, the Law Society introduced National Wills Week, which was observed a few weeks ago between the 16th and the 20th of September. So I thought, wow, let's have a conversation and understand why wills would be given a full week for us to engage around. But just to set the scene, statistics in this area say that 7 out of 10 adults die without a valid will in South Africa. Sheila, welcome to the podcast.
Thank you, Wendy.
I'm excited to have you here. And what we normally do in the podcast, we allow our guests to share who they are, their background, anything that you feel you'd like to share with us, whether you want to share more or little, it's up to you, but we just need to understand who you are, your career, and what you do.
Thank you, Wendy. I'm very, very grateful to be sharing space with you today, and I trust that what we discuss today will add value in the lives of your viewers.
Yeah.
As you've mentioned, my name is Sheila Ann-Robey. I'm a certified financial planner and practicing attorney. I've been in the financial planning industry for the last 7 years, and 6 years prior to that I was solely practicing as an attorney, specializing in professional indemnity. My career has started from humble beginnings. I was raised in a way where my family experienced massive financial loss, and that sense of injustice as a child was part of the reason I had this massive drive to become someone that could impact change in society. The law is something that I fell in love with, and it's something that serves me now in the financial services industry. And I found that throughout my career, the greatest gift that I can give another human being, especially a South African, is the ability to take control of their finances.
Wow, that is powerful.
Because one of my catchphrases is, where your heart goes, your money follows.
Wow.
So here we are today.
Awesome. Okay, so anyway, I just mentioned earlier on that the Law Society came up with National, Wills Week because of the statistics that I shared. But I think what I'd like us to start with is to explain what is estate planning and what are the key elements that fall under estate planning holistically.
So within the financial planning sphere, estate planning is one branch. Basically what it means is that after you die, there's a whole series of events that take place. It's very expensive to die in this country, and to plan for that before one's death is an essential and critical element of the financial planning journey. So any qualified financial planner will definitely include the estate planning and all that takes place within that realm. One thing, for instance, is tax. Another is, childcare. Depending on each client's circumstances, there are different elements to estate planning in itself that us as financial planners have to advise our clients on and assist them to prepare for, so that in the event of their death, everything is taken care of.
Yeah. Sure, it sounds weird, that we have to, plan for death, when we are no longer here. And I love saying to people, when you go on retirement like I have done, you retire to live, not to die. But here we are today talking about estate planning. Okay, maybe let's start by defining what a will is and why it's so important to have one as an individual or for a family.
So a will in this country, legally speaking, is a written document So either a testator or a testatrix, whether you're male or female. You can have a joint will as well, which is two separate legal documents in one document. So if you're a married couple, you can have one legal document, but it will declare both wishes. And it's just a document that sets out what happens to your body, your finances, your assets, your liabilities after death. In order for a will to be valid, it has to be written, it has to be signed by the testator, the testatrix, as well as two independent witnesses over the age of 16.
Okay. So what are the ideal things that you put in a will? Can I also add in there, I love shoes and I've got great shoes, and maybe I just want to apportion some of my shoes to someone. What are some of the components that one can add into a will?
So you can almost put anything in a will. I've had some very strange requests in my career. I mean, and I'm sure we'll touch on them as we go. But shoes specifically, because that's a movable asset. You can put a directive in your will to say, I leave my entire shoe collection to my very dear friend X, Y, and Z. Yes, that is allowed.
Okay.
I will give you an example of something that isn't a valid or legal instruction to be left in a will. I've had requests before where, a husband will put an instruction in his will to say, I leave this to my wife on condition that she doesn't ever remarry. So it's not necessarily legal or executable to rule from the grave. Us in the legal fraternity use the expression, you can't rule from the grave. So if it's a condition that's a future condition, it's very difficult to implement that for the executor of your estate. And I'm sure later we'll touch on, what an executor is and who the heirs and the beneficiaries are in a will.
Okay, that's awesome. Maybe let's do that while you are at it. Let's just go into that as well.
Yeah. When I sit down with clients, it's very important for them to understand there are very different ways in which you can have a will executed. It's you can have one done at your bank, your financial planning institute, your financial advisor can arrange for one to be drafted, or an attorney can draft one. It is possible for someone to draft a will themselves. However, because they don't have the expertise when it comes to estate planning or tax implications, it might be that the will that you draft for yourself might not necessarily be valid or legal or have instructions that are executable. When you draft a will, it's important to appoint an executor. You can appoint a natural person, a family member, a friend, a loved one, as the executor of your estate. In this country, however, when an estate gets wound up, it's done through the master's office. If your estate is worth more than 250,000, which most estates are, if you just tally up all the things in your house, it's probably worth more than 250,000. You are required to have a professional prepare what's known as the liquidation and distribution account, which is basically a tally of your assets and your liabilities. That document then gets given to the master's office, and that's how your estate gets wound up. If you're appointing a family member who's grieving, and they don't have the expertise to set up a liquidation and distribution account, it's an incredibly difficult process for them to deal with grief and then trying to do something outside of their natural field. They will then, however, be required to find a professional, either the bank or an attorney or an accountant, to assist them. And those things cost money. So it is better to have a will professionally drafted and to appoint an executor that will be able to have the skill, the competence and expertise to wind up your estate. It just makes things so much easier for the people you leave behind.
Yeah. And maybe, Sheila, I just want to understand the powers of an executor. Because I think I'd like my viewers to have a full understanding of the role of the executor. Being appointed as an executor, does it mean you control what's going to happen, or how does that work?
The executor's control is very limited. And remember, the will is a legal document that dictates the wishes of the deceased and the deceased estate. the executor doesn't have full control. However, they have some limited control. So if a wish or an instruction in a will is not attainable, so let's say, for instance, you want your children to have Jaguars by the time they are 18. If that's not necessarily possible, it is within the powers of the executor to do what's best in accordance with the will. So, I mean, obviously from that kind of will, you can see that the children and their well-being is at the forefront. So whatever cash is left, the executor will use to maybe not get a Jaguar, but maybe a Atos or something.
Yeah. Oh, okay. No, I thought it was important that we just chat about that. And of course, if you pass away and you don't have a will, what happens?
If you pass away without a will, or your will is not valid, then you are deemed to have died intestate. And that is just the legal term to say you've died without a will. There are laws of intestate. So in general, if you die and you are survived by a spouse, it will go to a spouse. If you are survived by only children, so depending on who you survived by, that is how your estate will then be wound up and divided.
Okay. Okay, we've already touched on the fact that if you die without a will, then you die intestate. And of course, the master of the court would appoint an executor if maybe in the event you don't have a spouse, and then they can pick anyone.
They can pick anybody. So it will be an officer of the court in general that will be appointed as your executor. And they will choose the easiest route to wind up your estate.
Yeah.
And that might not necessarily be in accordance with your wishes.
Yeah, sure. No, that's hectic, eh? And you know how life is. They'll pick probably the person that you didn't even like, and you can't do anything
your estranged brother is now getting your PlayStation, heaven forbid. Yeah.
Okay. Now, there's a myth out there that I really want us to talk about. People say, no, only the wealthy need to have a will. How true is that? And then some say, I'm too young for, having a will.
I would love to debunk that myth. I think it's important for every South African at any age to have a valid will in place. Not only does it, regardless of your assets or your wealth or status, it just creates certainty for the people that you leave behind. They know who and which executor will be appointed. Everything that's left behind has a purpose. And it just makes everything administratively far easier. So it is something that I encourage all clients to put in place.
Okay, so you've already mentioned, at the beginning that you can draw up your own will, or you can use a professional, either an attorney or your financial institution to assist you in doing that. Now, I've been on social media and I've seen so many people talking on social media, no, it's expensive to draw up a will, rather do your own. What are some of the dangers of drawing up my own will? Because I'm not a legal person. What are some of the mistakes that can go into that will that makes it, makes it to be unable for it to be executed?
I'll give you a few examples, Wendy. So let's say, for instance, I draw up a will and I leave 100% of my estate to my spouse. And I have that spouse sign as witness. That will is not valid and is not executable.
Okay.
If I'm survived, if my spouse and I die at the same time, then that will is not executable because it doesn't make provision for different beneficiaries. So there are specific ways in which to draft and certain clauses that need to be included to ensure that there also substitution. If, for instance, there's a thing called a usufruct, so perhaps I would like to leave my entire estate to my children, but I don't make provision for a testamentary trust to be set up. And I don't necessarily want my spouse to get their hands on the funds, and I want it to go to my children. If I haven't made provision in the will for a testamentary trust, my spouse will have access to those funds as the natural guardian of my children. So there are certain clauses. I won't even start on tax because that's an entirely different thing. We're all at the mercy of SARS. And these are just some of the things that a lay person might not take into account. You can draw up a very simple will and say, I leave 100% of my estate to X, Y, and Z. We haven't made provision for your remains. We haven't appointed an executor. We haven't made provision for a substitution. All such things. So I really encourage people to find a professional. In this day and age, there is access to so much free will drafting. But again, another caveat in that is that you get what you pay for.
Yeah.
So most financial planning professionals like myself do offer will drafting at a very low cost, if not free. So most people's financial institution, the banks, will offer the wills at either free or a very low cost, and usually have a safekeeping fee. That's another thing that I would like to encourage your viewers to consider, that if they're not getting their will drafted by a professional and there isn't a safekeeping area, so either at your attorney's office, your tax practitioner's office, or your banking institution, that original will for you, because all that matters is the original document. If that original will is in your house and you perish by fire together with your original will,
goodness,
you die intestate. So it's just about creating this, mitigating all these risks, and in order to do it properly, just get it done by a professional.
Yeah.
We are out here.
Yeah, and you offer the best. Okay, so I want to go back to this topic because I saw people having a conversation around that to say, once I have passed on and I have a will, of course, then somebody, the executor, must wind up the estate. And that is where people are saying there are lots of costs. Can we talk about that, if there is something that one could do to mitigate not, leaving your beneficiaries to pay these high costs that are being spoken about?
Excellent question, Wendy, and this is one that I'm particularly passionate about, because this is really the crux of financial planning.
Yeah.
When you do a proper financial plan, you're really essentially planning for your life. Estate planning is planning for your death, and that we need money.
Yeah.
So the standard fee for executors is 3.5% of your estate, which a lot of people are very disgruntled about. But the administration to wind up an estate, on average, back in the day, it used to take about 8 years to wind up an estate. It's a lot quicker now. I would say you can bank anywhere between 2 to 2.5 years to wind up an estate. And that's purely because the process is so administratively heavy. We are also at the mercy of the master's office. We are at the mercy of SARS. Remember, SARS is the first person we pay. Tax is the first thing that we have to settle. And that costs money.
And the tax comes out from the estate?
The tax comes out from the estate. If, however, you haven't made provision for that and there's no money, the people that are left behind have to pick up the tab.
Oh my Lord.
So it is essential, and the easiest way to do the estate planning and ensure that there's estate liquidity is through a simple life policy. So putting a 200 or 300 Rand life policy in place that pays cash directly into the estate late bank account, which your executor will open, ensures that the water and lights can be paid for your spouse, your surviving spouse, while we're winding up the estate. It ensures that we can pay SARS. It ensures that we can pay your creditors if your normal financial planning and life policies haven't made provision for that. It ensures that we can pay ourselves so that we can drive to the master's office, so that we can make sure that we can go to, to go cancel your TV license, all of those things. There needs to be money to do that.
So it's actually advisable that, and I love it because you are a certified financial planner. You're not a fly-by-night,
No.
so you can give advice. So what I'm trying to say here is that it does make sense, and the advice that you are offering is that if you have drawn up your will, make sure that you've got a life cover that will pay out when you pass away, so that everything can be taken care of. The children can go to school, etc., etc.
Exactly. So there is a really good way, and my colleagues in the industry, because the financial planning industry has, grown in leaps and bounds in the last decade. You'll have a life policy that pays, to your beneficiaries directly to avoid tax. You'll have an additional life policy to pay to your estate, which might be taxable, but there will be cash. So it will be two separate. So there's different ways to skin a cat, and every single family and individual needs different things. And us as financial planners, us as attorneys, we need to be dynamic in what clients need, because each one is entirely unique.
Okay, because one of the things that I've seen happen is that when someone passes away, as soon as Home Affairs has issued the death certificate, Home Affairs is now connected to the bank, to the banks, and then immediately they freeze the accounts.
They immediately freeze the account.
And then you are unable to access the funds. What can one do to circumvent that?
Again, life policy. Remember, the people that you leave behind are grieving. The last thing they want to do is go and fight with the bank. I think the quickest turnaround time for life cover that I've seen in my last, in my tenure in financial planning is about 48 hours.
Okay.
From receiving every single requirement.
Right.
If your spouse, if those debit orders are coming at the 25th and the 1st of the month, the water and lights, the groceries, the house, the car, all of that is coming, and they don't have access to your bank account, the pain coupled with that grief is just unsurmountable. But within, a death certificate is relatively quick to issue, and once all the requirements are received, for your spouse to receive money in the bank account before those debit orders go off, so that they can actually focus on grieving you and planning a proper send-off. I mean, what a gift you can leave for the people to leave behind. It's going to suck. It's hard either way.
Yeah.
Let money not be the one thing you worry about.
Okay. Well, I still have more myths that I'd like us to
I'm here for
debunk.
it, Wendy.
So, when I talk to people, when I do the financial literacy chats and have conversations with people, some will say, no, Mina, I don't have a lot, therefore I don't need a will. Or some say, my family know my wishes, so I don't need a will. I've verbally communicated. Or my family will look after my kids after I pass on. And then the one that I like is the young people who are working. They say, oh no, I'm too young to have a will. Can we demystify these?
Please, Wendy. I'd like to start with, verbally communicating your wishes.
Yeah.
And in my experience, and having wound up a significant amount of estates, the minute someone dies, money makes people vicious.
Yeah.
And it's a very sad reality.
Yeah.
And it's such a simple exercise. It could take you half an hour to draw up a legal document that can negate all of that, so that your wishes can be adhered to. So often, sometimes even with the presence of a valid will, after someone's death, a family where there's fighting about money,
they contest it.
It's contested. So why not take that away from the people that you leave behind? I think also, especially if you are a parent and you're leaving behind minor children, it's every person that has children has to have a valid will in place, because perhaps there's a circumstance where you and your spouse pass away simultaneously. Perhaps the other parent is estranged. And remember, they become the natural guardian.
Yes.
So even if you don't have a will and you wanted your children to receive everything, you're estranged, you know, the other parent will have access to those funds. So it's just, I'd rather why leave everything up to chance?
Yeah.
For young people, remember, when you're young in your career, it's not something that is a priority.
Yeah.
But a 13th check or a bonus or a something, or you've purchased your first property, the last thing on your mind is drafting a will.
Yes.
But these things happen, and as long as you've got a valid will in place, even if it says I leave everything to my parents, that's fine. It takes away, you know, the questioning. It takes away the fighting. It makes the administrative process so much easier.
Okay. Now, maybe let's just go back to the drafting of the will. And you know, in these days, we've got blended families.
Yes.
Or you have a child that, you know, you had before you got married. And when you draw up your will, you exclude them. Or there are people that you've been supporting. What is your advice to someone that has that kind of situation where they've got children with their spouse, but children that are not part of this union that they have? How do they take care of them? If they leave them out of the will, what would happen?
I would say if there is a divorce decree and a maintenance order, that's one thing. Remember, even after you die, a maintenance order is, you still have to adhere to that maintenance order. That contract supersedes your death.
Right.
So if you have children from a previous marriage that you still support in terms of a maintenance order, your estate has to honor that.
Okay.
Regardless
whether
of
you
whether you've
or
added
not.
them or not.
Okay.
So a maintenance order is a valid legal document that supersedes the will.
Sure.
If, however, you would like to include those, I've had many situations where it's from a previous relationship or an extramarital relationship even.
Hectic.
To make perhaps in a situation where you don't want your spouse to know about the previous relationship child, or it's not something that's privy in your new relationship. In that instance, perhaps you could have a separate life policy where that child is a beneficiary and receives that money directly.
Okay.
If that child is, however, a minor child, the natural guardian will receive that money.
Okay.
So there are, in the financial plannings, the insurance companies do have their own trusts where it can be made available to children if you don't want to be including them in a will.
Okay. No, thank you for that, because I thought it was an important aspect that we need to touch base on, so that you avoid the delays when they're winding up the estate, because then there are other beneficiaries that were not included that are now, you know, making claims to the estate. Okay, so how often should one update their will? If I've done my will 6 years ago, is that fine, or how long should I be updating it?
If you have a relationship with a financial planner and they do their regular annual reviews, they will always check whether your will is still valid and it's up to date.
Right.
If that's not the case, I mean, usually a client is. So, Wendy, if you've done yours 6 years ago and nothing significant has changed in your life and your wishes are still your wishes, there's no need to update your will. That will is still valid, still stands. You could have even done one in 1986, and if the wishes are the wishes, it still stands. Every time you do a new will, it should have a clause that would revoke the previous wills, so that those wills are not considered valid. The newer dated will, if it is valid and it revokes all the previous ones, is the wishes that will stand.
Yes.
So often we'll have situations where clients will do on their deathbed, they've now reconsidered their entire life and want to do the will. In that instance, it's very important to be compos mentis. As long as there's not a doctor's note that says this patient was non-compos mentis when they signed this will, that will be valid.
Okay. An unsigned will,
Yes.
is it valid?
Not valid. Not valid, please. I have so many, and to be honest, as an attorney myself, and I have many clients that are attorneys as well, They are like hairdressers that need a hairdresser. They've got a will that they've drafted on their desk for signature, never sign. You'll be surprised how many attorneys die without a valid will in place.
Sure. So basically it must be signed. It doesn't matter whether I had made my intentions known to anyone in a court of law. That wouldn't stand until it has a signature.
It must be signed by yourself, 2 independent witnesses, must be dated, must be in writing.
Yeah, and you must sign it when you are still mentally...
Compos mentis.
Yeah, compos mentis. I wanted to claim, because maybe somebody watching will think, what is compos
Of sound mind.
Of sound mind.
Of sound
yes.
mind. Yeah.
All right. So now, Sheila, what if I've drawn this will and nobody knows that it exists? Should I tell someone, or what happens? So if it's at the bank, what happens when do they pick up that I've passed on, or what is the process?
It's a very good question, Wendy, because I have a lot of clients that are single, elderly people that don't have loved ones. In that instance, you know, if they pass away, hopefully there'll be a neighbor or whatever who will check.
Right.
And then surely the process will start. Someone will step up and say, we'll search the house. Is there an original will available?
Sure.
We'll start looking at the institutions. So often I'll have clients of mine who have lost loved ones that will come to me to say, what do I do? What is the process? We haven't found a will, and then we'll go through a process of checking with each institution or trying to find if there isn't any documentation. So it's also something that I encourage your viewers to prepare, is what we call an ICE file. It's an in case of emergency file, and this should have a copy of your will, if not the original will, if that's held at the bank, your policy documentation, where you've got financial instruments, your passwords to your phones and your social media. And if you can have an in case of emergency file and your loved ones know about it, it just makes the process that much easier. I know it's an awful thing to think about and prepare for death, but you never know when it's going to happen to you.
Yeah.
So for me in the industry, every time something changes, every single loved one gets an email to say that in case of emergency file has been updated, just so you know, it's the top shelf of this and this and this.
Yeah.
So
okay,
to take that stress and pain away.
Yeah. Okay. Sure. Then, because I'm just thinking, if you haven't stored your will at a reputable organization, it's in the house and the house does burn down, then literally there's nothing to fall back on. Okay, now there's something called a living will. What is a living will, and what are the benefits of having one?
A living will is really exactly what it says. It's your wishes while you are still living, but unable to make decisions for yourself.
Right.
So in an instance where you are medically unable to make decisions for yourself, if you are declared brain dead, or you're in an induced coma and the likelihood of you surviving is not available, and your family members need to make a decision about you medically, your living will give instruction to that, to say, after 30 days, or if I'm declared brain dead, please, finished and klar. Because remember, while you are still medically alive, your will can't be executed.
Right.
So it's important to leave a living will behind as well, so that your family members or the medical professionals can make decisions, so that towards the end of your life your wishes are adhered to.
Yeah. Because it puts a lot of stress on your family if you don't have a living will and you are incapacitated. You're probably in a coma or whatever, and the doctors are now, putting the pressure, not pressure per se, but the family needs to make a decision whether to switch off the machines. I don't think that's an easy decision to make. I mean, I always joke around, but it's really serious too when I talk to people, to say you must have a living will, because from what I understand, is that when you are in a coma, you can still hear. Some people can hear the conversation, but they are unable to respond. So probably the doctors are standing there with your family and they're saying, okay, you need to make a decision whether you're switching off the machines, and you are trying to say, no, I'm still alive, but nobody can hear you. And you literally hear people planning, to switch off the machine. So I just want to, encourage those that are watching that it's not only a will that looks after things when you pass on, but while you are still alive, make sure that you have a living will and you state what must happen, to you in the event that you pass away. Is there any other type of a will that we didn't touch on that you'd like to maybe voice over?
I'd also, not necessarily a will, but a DNR, do not resuscitate, is also something that will be included in your living will. Let's say, for instance, you are suffering a chronic illness, a terminal illness that renders you almost incapacitated. And if in the instance that, let's say, you suffer a stroke as a result of your terminal illness, and then it renders you brain damaged, you can leave a do not resuscitate order for your medical staff to ensure that you never actually go into, so they will allow you to pass away naturally without trying to resuscitate you and then leave you in an incapacitated state, which would then call for the living will to be applied. Another document that's very important is the power of attorney, which gives one of your loved ones the ability to make decisions for you, specifically administratively and financially, if you are incapacitated to do so. Some of the financial institutions are not necessarily accepting power of attorneys, and then it's a requirement to make an application to court for curatorship, so medical curatorship, where if you are rendered incapacitated, the court will then appoint a curator to act on your behalf.
Sure.
So it's hectic.
It is hectic.
And it's things that we really, really want to avoid, and it's painful to deal with, but imagine it's you that's left behind having to do this. You'll be very grateful for your loved one if it had to happen to them, that you were guided in such a way administratively. And these things are very easy and possible to adhere to while you're alive and kicking.
Yeah. Okay, is there anything else that we are leaving out, with regard to the will crafting that you'd like to share? Otherwise, we will move towards the closing of this conversation. I must say, I have a lot that I have learned as we are sitting here, and I'm really excited for the viewers because they're going to gain a lot of wisdom from this conversation.
I think I'm good, Wendy. I think that's the basic crux of it, and just to encourage your viewers that we're in a day and age where information is possible and education is possible. And there are a lot of people like me that really are passionate and want to educate. And these services are for free. We're out there. Educate yourself, empower yourselves. If it's not something that was passed down from your parents, after the age of 25, it's your responsibility to make sure you're an informed adult.
So if someone is watching and they really would like to contact you, where do they get hold of you?
They are welcome to Google Sheila Ann-Robey. I do have my own website. I'm an affiliate member at a financial planning institute, and they can find me on every other social media platform as well.
Wow. Okay, so at the end of the podcast, I always ask my guests to scatter a seed of wisdom. One thing that when they think of episode 29, wherein Sheila was, engaging, the one thing that will stick with them, that seed and that nugget of a seed.
I think for today, from my side, Wendy, because we're dealing with estate planning, it really has validated for me my motto and the thing that I live by as a financial planning professional and an attorney, is that where your heart goes, your money follows. Yeah.
Where your heart goes, your money follows. Thank you so much, Sheila, for these wisdom bombs that you've dropped today. I'm hoping that, indeed the viewers will truly, do an introspection and check if they do have a will or not, and make sure that as soon as possible they draft one. So thank you for watching and continuing to watch the episodes, and I'm really grateful for the positive comments and some topic suggestions that have been given to me. Above all, I'm happy that you are sharing with others and that you continue subscribing. It's easy to subscribe. Just click on that subscribe button and you will not miss any of these empowering episodes. I just want to also remind you that my book, I Wish Someone Had Told Me, is available on my website, wendysilibi.co.za, and on Amazon. So yeah, thanks for the support, and until next time, please go out and implement what you've just learned. As I always say, knowledge is not power. Applied knowledge is power. Until next time, thank you.